the state follows up on that. That's not like a double punishment. That's just a matter of procedure, correct?
Right. I mean, I guess it could be interpreted as a double punishment, but there's two distinct consequences if an educator conducts some kind of misconduct. Of course, the local school district, as the employer, can take an employment action against the educator, and whether it be suspension, a reprimand, or termination. However, whatever the local school district does doesn't affect the license of that educator. That's where the state board steps in. So if a person does something that maybe doesn't rise to the level of something that their license could be taken away, such as maybe they called in sick, and their superintendent found out that they weren't really sick, they went on vacation instead. That's a personnel issue that would be addressed only by the local education agency. But let's say, for instance, it rises to something to the level of a licensure action. For example, they are sick at school because they are under the influence and they are drunk and they're throwing up. Obviously, the LEA would want to take some kind of employment action against them, and because they violated their employment agreement with the LEA. But then also the state board would want to take some licensure action because having an educator license is a privilege subject to certain terms and conditions. So it is kind of, in a sense, a double punishment because there's two layers to it, but I think they're two very distinct layers. Because an employment action won't always rise to the level of a licensure action, but almost definitely a licensure action would also have some kind of employment action attached to it, I would imagine.
Well, thank you. You explained that very well.
You're welcome.
Any other comments on that particular piece? Elizabeth, is there anything else from the TEA public comments that you want to comment on? And in particular, did you attempt to incorporate most of their suggestions, or was there anything that you did not include that we should be aware of?
Well, a lot of them were more sort of technical corrections, which I think we covered in revising the rule. Some of them we wanted to wait and kind of weigh in with the subcommittee where they stood on them before we incorporated them into the rule. And so I think some of them are well taken. The first one, loan default provision, is also listed under good cause, which I think is true. If it's an automatic suspension, then we probably don't need to include it under good cause since it's already addressed in the automatic suspension. So I think that's something that we can definitely change if the subcommittee agrees that it's kind of duplicative.
Okay, before we move away from that, does Wendy or Allison, do you have any, do you agree with that? Do you have any issues with that?
I agree with you.
So that's on the second page, 2BI.
I agree. This is Wendy. Sorry, I agree.
Yes. Allison?
I agree, yes.
I do too. Okay, so we can make that change. What else, Elizabeth?
They're suggesting that if a felony is not an offense listed under subsection 2C little I1, the educator has a right to a hearing. But I think don't they have a right to a hearing for anything?
Yeah, well, except for
Automatic
revocations, yeah. Anything that isn't listed as an automatic revocation, or now we have listed as the automatic suspensions with student loans and the child support payments, which are automatic suspensions due to other statutory provisions. So anything that's not in those two groups, there is always a right to a hearing.
So the way that it's written, do you all think it's clear enough that that's true, or is there any additional language that needs to be added to ensure that it is clear?
I think perhaps we can change that line from upon receiving notice to that an individual has been convicted of a felony, the board shall revoke, to the board may revoke. And I think that'll clear up any confusion.
Is everybody else okay with that?
I'm good with it. Thank you, Cindy.
Good. Okay. Moving right along, because I know we could take a lot of time with this alone. What else? Any concerns about incorporating any of these other pieces or anything you want to highlight? Because I know you're asking for our input. What I read seemed reasonable, but again, I certainly don't work with it the way that you do on a daily basis. So if anybody else has any comments or suggestions, whether it's Wendy, Allison, or you, Elizabeth and Phil, welcome to, so that we can move on. I don't want to short circuit this, but by all means, let's make sure we're adding what needs to be added from their recommendations.
Okay. Philip said he's seen pretrial diversion granted for felonies. This public comment is asserting that you can't get pretrial diversion for a felony of any class. Wendy, specifically, I know you have been a criminal defense attorney. Do you know that to be true or not? I don't have much experience in criminal law.
I mean, unless the statute changed, I can check, you certainly could get pretrial diversion for a felony when I was practicing law. There were limitations, and I'm happy to, while we're talking, I can pull that up and look.
Yeah, I'm logging on right now. So I guess we can circle back to that one really quick. But I have some.
I'm sorry, and can I just add, there's, and I need to look at the language that you guys use, but there's pre-trial diversion and there's post-trial diversion.
Right.
So there's the 4035 group of two, which is it's not post-trial, post-adjudication diversion. And I need to look at the language to see if they're both covered, but I'll pull up the statute and see if there's some change on pre-trial diversion. But
I think right now our language just covers pretrial diversion.
well, I think it may have. Can you direct me to? I have it in front of me, but the section.
The statute that we reference for pretrial diversion is 40.
No, I mean in the rule.
Oh, well, we have it in the new revision defined under conviction, just the very first page.
Inappropriate. Okay. You could also solve that by just taking pre-trial out of it, an order granting diversion.
Okay.
Because that would cover 4035. Once you complete the conditions of probation, you get it expunged. It's basically expungable probation.
Right.
Sounds good to me.
All right, so I'll look at it just to satisfy my curiosity.
Okay. Any other comments?
Are you taking comments just
to
only?
Modify that language, what you're just saying, but Wendy, you're going to do a little more research?
I'm looking right now, just at the diversion statute for the I think you can modify that language, it actually doesn't matter, but I guess if it says, yeah. I think that language covers and you can certainly get 4035, 6 months of probation for certain enumerated felonies.
Mm-hmm.
So.
In this case, I'm personally looking to the lawyers and tell us how we should change it or modify it.
I think the reason that we stuck with the pretrial diversion is because that was the language we had in the old rule, and not necessarily because we determined, pretrial is something that we needed to look more carefully at than post-adjudication. So I'm certainly happy to make sure that the language is expanded.
Wendy, what do you think? You still reading?
Yeah, I am
Well,
still
it does
reading,
say,
but,
in the code, it
but I mean,
says
if
you
you're,
can't get it for a felony.
I think where there may be confusion is if you have a prior disqualifying felony, you can't get diversion, but you can get diversion for some felonies, so.
In 4015-105,
Right.
it says a qualifying defendant is one who meets the following requirements. The defendant has not been previously granted pretrial diversion.
Oh, you're right, yeah.
The defendant does not have a prior A or B misdemeanor or a class of felony, and the charged offense for which the prosecution is being suspended is not a felony.
Yeah, okay,
So they are correct.
yeah.
That's new, let me look at the, okay.
So you cannot.
So then you'll make the change accordingly, or do you?
Yes, we will make the change accordingly. Or if we, can you get post-trial diversion for a felony?
4035-313 is that statute, and unless that one was changed in 2014 too, yes, I will look at that now.
Because in that case, we can just leave it as diversion, and that'll cover both, right?
Yeah.
Okay. Do we need to wait for Wendy to look up the other one?
No, I can look at that,
to there.
we'll move on and we can come back to it, it probably makes the most sense. I'll
So
just
the
pull it up.
technical
4035.
correction which follows that one, anything there, or do you all recommend we add all of those technical corrections, or have you already done that? I know you said you were waiting for some things to be buttoned up.
Yeah, and I think
Yeah.
a number of the technical corrections, we had to hold off until we actually knew where everything was going to shake out in the format of the rule. So I think we're planning on incorporating those. We just wanted to make sure that everything is going to point to the right place.
So I think as they were in relation to the first version that we submitted on first reading, that I think they were well taken. So now it's just a matter of matching them up to the revisions that we made. Of course, we added the definition section, so things like shifted around. So, but I think most of the corrections were well taken, and there were some grammatical errors that they pointed out that will be fixed.
Okay, great. I think, from my perspective, it sounds like that covers the public comments from the TEA, which we are very thankful for, unless there's something else that you, Elizabeth, or Philip need to add before we move on to the revision of the rule.
No, that is it as far as public comments are concerned.
Okay.
And just to close that, that loop on, post-trial diversion or expungable probation, 4035-313 still is allowed for felonies. They exclude certain felonies, but there are felonies that it's allowed under, so.
Okay, so changing it to say diversion will be inclusive then.
Yeah, it might, I mean, Elizabeth or Philip and Elizabeth, I would leave it to you, but you may want to diversion under PCA 4035-313 and then cite the other diversion statute too, just to be super clear, because 4035-313 in the captions doesn't mention the word diversion, so I just want to be, so that it's super clear what we're talking about.
Okay.
Mm-hmm.
So we just cite the two statutes, I think that makes it abundantly clear.
Okay.
Great.
Great suggestion. Thanks, Wendy. Okay, so we're going to move into the revision of the rule. Hopefully everyone had an opportunity to review the recommended changes that were incorporated into the revised document that we were sent yesterday. Wanted to hear feedback from you, Wendy, and Allison, to see if you have any comments, recommended changes. I know I had a couple of things, I think I copied all of you on it, but I want to hear from you all first, because honestly, I think we need to discuss a couple of things that I've suggested that might not need to be incorporated after thinking about it again last night. But let's hear from you two.
It'll shock all of you that I have a couple. But they're not huge, and a few of them are things that we talked about before. So in 4C, so 4C, it's all the same change. 1, 2, 3. I'm sorry. 4C, little Roman numeral 2, subsections 1, 2, and 3. Little numeral 3, subsections 1 and 2. Little numeral 4, subsections 2. Little Roman numeral 5, subsections 1 and 2. We just need to add in the after up to, we need to add and including.
Right.
So
Right.
for not less than whatever that is, up to and including the higher one. And I think we talked about that before. I don't think I specified it exactly. So.
That's a great suggestion. Anything else, Wendy?
I'm looking at, I like, on my airplane yesterday did these, so I'm trying to see what else there was one, I remember, these were all like sort of just technical. I thought your changes covered,
One thing too, Wendy, that you had mentioned that I would like to get your input on is the upward and downward departure.
Right.
And the wording on that. Because that was not included, it's not included currently, but I know it's something that we agreed should be included. And so kind of fleshing out the wording on how we want to address the board's ability to deviate from the recommended ranges in certain situations.
I mean, I would probably suggest language and that you figure out where it goes in here, but nothing in these guidelines is meant to prohibit the board upon good cause shown from, some like making exceptions outside of the range of punishment recommended or something like that.
Okay.
You know? That sound good?
Sounds good to me.
So it's not like the norm, but we're saying that it's not prohibited. That's sort of.
I'm looking at that. Wendy, Allison, sorry.
Yes, I do have a question. I want to be sure Wendy's finished.
Yes,
Wendy, anything
on
else?
that. I have, not on, Allison, is it on that, or is it on, I have one other technical?
It's on another.
Okay. Do you want to do it, or do you want me to do this other?
So Wendy, why don't you go ahead and complete yours?
Okay, so I think, and it's just like I think it's just like a return under okay, so disciplinary action, so 4C, let's see where it is, 4C, little Roman numeral 6, or I'm sorry, yeah, I think there needs to be a return so that 7 is similar offenses. On the one I got, similar offenses within that same paragraph.
Oh yeah, you're right. I see it.
There just needs to be. I mean, it was just like hit the return button. So and then it becomes. So then you have 7.
Gotcha.
Is similar offenses. 8 is nothing in its part.
Yep.
And then 9. And then you may want to put somewhere. You may want to add the language we just talked about somewhere in there. But right now, so that was the only other technical thing that I saw.
Yeah.
Perfect. Thank you for catching that.
Great. Thank you, Wendy. Allison?
Sure.
All right, I'm looking at 3E and also Roman numeral 6 regarding the inappropriate physical contact.
Yes.
And my question is this. That's pretty broad. Should we have more specific language like we do with the verbal contact? Because the verbal contact is very specific. But the physical contact, and to the case we had just in our last meeting, where the guy wrestled and it was consensual.
Right. Yeah, I think it would be useful to have cleaner and clearer language in it. I think part of when we were doing this revision, we were struggling with how to phrase some of it, I think. And so that was one of the ones that we wanted to rephrase, but we haven't been entirely clear on how yet to be certain that we're not.
This, to me, we're stating here that there's permanent revocation, correct? I'm looking at two computers at one time. So, if we're looking at permanent revocation, would that be the same for someone who had touched inappropriately in a sexual manner, or some coach wrestling and son? I mean, right, neither one is appropriate. But I do think there's some levels here. If we're talking about permanent revocation,
Right.
as a teacher, I would like to see it more specific.
Right, and I think that we inadvertently left out there is a range that was supposed to be in that.
Well, according to the chart, this is Lillian, but according to the chart, unless I'm misreading this, inappropriate physical contact has a range of suspension of 2 years, including up to revocation.
Right, and it sounds like we might want to expand that range somewhat to take into account, the varying levels of what sort of contact could be construed as inappropriate.
Yeah, but then the subsection, I think what Allison's talking about is the subsection just says will have his or her license permanently revoked, doesn't have the range in it.
Right, and that needs to be corrected.
Yeah, good catch. I didn't catch that.
So then, since there's a struggle with the language and the terminology, are we required to come up with that today, or is it possible for us to submit those to you, and in particular looking for Allison to provide some great guidance on that, and then in workshop on the 21st of July, we could review those insertions? Is that an option for us?
I think that option is totally viable, yes.
Because then we'll do final reading and vote on July the 22nd.
Yeah.
Yes, ma'am.
Okay. So rather than try to figure out the language today, if all of us would certainly recommend suggestions to you via email and copy each other, I think that would be beneficial to moving that forward and getting it as clear as we can. And then in terms of ranges, if we want to recommend those ranges as well, we can certainly do that too.
Perfect.
Does that make sense, Wendy and Allison?
Perfect. Yeah. Yeah.
Okay. Allison, what other items do you have?
No, that was it. That was my only concern.
Well, I had a couple that I copied you all on yesterday, and now that I think about it, I'm not sure that the one that I inserted language on, which it's in the very first page, which, oh, by the way, is it appropriate to number our pages? Can we do that going forward, or is there some reason why we don't number the pages?
Our rules usually, I've never really paid attention to how, I'll double check. I know the Secretary of State has guidelines for rule formats, but let me double check.
Okay, so it's on page 1, number 1B, the last section of that, let's see, it says, the last sentence, a teacher who has been reprimanded by the board will receive a letter from the State Board of Education indicating that the inappropriate conduct is discouraged. And I said it could result in further disciplinary action.
Yes.
Maybe it's if repeated or some other language, but tell me if you all think it's even appropriate to, in that letter of formal reprimand, let them know that if it continues, that it could lead to.
Oh,
I think
absolutely.
Yeah.
Yeah.
I like that.
Okay. Okay. So if repeated, could result in, or whatever the language is. I don't know if what I gave you was sufficient. Okay, and then on page 2, letter M, at the top, suspension, we have the last sentence that says, reinstatement may be subject to the completion of terms and conditions contained in the order of suspension. May be subject to. Well, so if they are, in fact, subject to, who's going to know and determine that, in fact, they have fulfilled those terms and conditions? Is that the LEA? Because how would we know?
Historically, that
we have clarification there.
Yeah, historically that has been the State Board Staff Review Committee taking a look at, for example, in the past I've seen documentation of teachers completing, teacher ethics boundary training classes, and they've sent in documentation of where the class was taken, how many hours it was, certification of completion, and the review committee has taken a look at that documentation and said, yes, this fulfills the condition on their suspension that they need to have educator training, or perhaps it could be if someone had been drinking in the classroom and we put a condition on that the person needs to complete medical treatment for alcoholism, and they've sent in rehab discharge paperwork and things like that. So those are things that have been done in the past, and we could be clearer about how it's done, but that's the way we've...
Well, it may not necessarily be that the wording here needs to be clearer. It's just a matter of, you have a process in place that before the person's license is reinstated, you are in fact reviewing that they have completed the terms and conditions if in fact there were some.
Yes.
And you have a process in place in your office.
Mm-hmm. And I would actually, now that you bring it up and I'm reading it, I think that the language might need to be changed, because as it reads now, it says reinstatement may be subject to the completion of the terms and conditions contained in the order of suspension, and that makes it seem like it's kind of permissive.
Yeah, maybe we should say will be.
I think reinstatement will be or is subject to any is subject to the completion of any terms and conditions contained in the order of suspension. So it's clear that if your order of suspension has terms and conditions, then they need to be done before you can be reinstated. Because as it's kind of mushy now with the may in there.
Or maybe completion of all terms and conditions.
Yeah.
Yeah.
Yes, I like that. Okay. So you'll make those changes. And then on page 3, 2B, there was an extra letter. So I wanted to point that out in small II. Failure to comply, there was an extra L. Did you catch that?
Mm-hmm.
Minor. And on page 4, Roman numeral 5, 2, there was an extra A. Shall be subject to disciplinary action. Minor, just take out that A. And on page 5, number 5, B, II, there was redundant language. Be eligible, not be eligible.
I think, yeah.
Person whose license has been revoked under parts 1 or 2 of this rule shall be ineligible to reapply. See what I'm saying, or am I reading this wrong?
Ineligible. Yeah, you're right. I think what happens is when we do these corrections and we find and replace, it gets kind of hooey sometimes.
Yes, no, I
thank you for catching that.
Okay, that's all that I had for the revision of the rule. And I think we covered Wendy's and Allison's fairly well. So now, Philip and Elizabeth, do you have any comments or questions for us before we talk about wrap up and next steps?
Yes, actually during our case review yesterday, we had something come up that we thought would be helpful, that's really not addressed in our rule as it stands now. And a lot of times we have people that come before the board either to get a new license or the transfer, and they have had a felony conviction, let's say 20 years ago, and they have to check that box, that says that they have a felony conviction, and then of course it's on our radar, and we have to decide, what recommendation to make to the board. Considering that our rule now says that anybody with a felony is going to lose their license, how do you think we should handle it when people are applying for a new license and they already have a felony? Do we have a bright line rule that if you have any felony, regardless of no matter how old, you can't get a license? Or do we want to have a bright line rule that says anything 10 years or older, you can reapply, or we might consider it? And one of the things that Nathan brought up when we were discussing it is we don't want it to turn into a anti-check the box movement where people aren't being truthful in their applications because they know they're going to get denied. So that was just something that we thought of that we weren't really sure.
And do we want to have categories of felonies that we can say, if you did X heinous crime to children, never apply as a teacher, or you had Y felonious conduct that, I don't know, maybe less morally reprehensible.
What's the statutory? I'm sorry. Go ahead, Alison.
Well, I'm just wondering, how do other professions do it? Lawyers, doctors. How do we compare professionalism? Of course, I know that teachers work with kids, so we do have to be more studious about this. We do not want somebody in the classroom that's been convicted of rape. I'm sorry, personally, I don't care if it's 50 or so.
Yeah.
Well, I think they're prohibited. I mean, if they're indicated, right?
Correct. Yeah. If they're indicated as a perpetrator of child abuse or neglect, then they're statutorily prohibited from being in the classroom.
But aren't there statutory provisions for some felony convictions too? Am I wrong?
I don't recall there being one about felony convictions in relation to other than the child abuse provisions.
So I can commit an armed robbery, and then, if I'm a teacher, I automatically lose my license. But if I'm not a teacher yet, I can apply to get a license.
Correct.
And that's the problem.
Correct. Yeah.
that we're trying
to. I mean, statutorily, that's okay.
I mean, obviously, if you committed an armed robbery and then the next week applied for your license, we would deny it.
And when we've seen it come up is a lot of maybe they were 18 and they got a shoplifting conviction, or possession of drugs, or
possession of drugs in 70s or 80s while they were in college, and then 20 years later they wanted to become a teacher. Where does that put us on our application process? And that's where we've been struggling as a review committee, or at least that's one of the places we've been struggling, is how old is permissive, I guess. At what point do we say we don't think a person can turn their life around? It's a tough discussion.
I mean, is there a way, because we have the ability to deviate, and maybe that language needs to be tweaked for current teachers and applicants too, but is there a way to say a person who has committed any of these offenses, which would cover the felonies, prior to applying to be a teacher, would be presumed all right, how about a person who has committed any of these offenses for which revocation is an option prior to requesting teacher licensure will be presumed ineligible, but, you know what I mean? Something where, if you've done the things that we would revoke you if you were already a teacher, it's presumed you don't get a license, but then you have that safety valve wiggle room in the other part of the statute. Does that make sense?
Mm-hmm.
Yeah, that does.
Maybe that's another item, another language that we kind of work on and think about and present at the workshop, or discuss via email and try to tweak it and nail it down at the workshop.
Yeah, that sounds good.
I think that makes sense. I like what Wendy said, but it sounds like there is some additional research that you all may need to do, and I would personally prefer that you do that and submit it to, if you want to submit it via, writing to us via email before the meeting, we can certainly do that, and then be able to weigh in back and forth. I think that's certainly an option that we should take advantage of.
That sounds great to Wendy.
Allison, you're good with that?
I'm very good with that, yes.
And we will do that then.
Okay.
And I think that was
Great.
the only other comment that we had.
Okay. So then just moving into to wrap up, it sounds like we know what needs to be edited, the changes that need to be incorporated. We are going to provide input, language regarding one of the sections, which just now escapes me. What did we agree to? I was trying to take notes. It was regarding the inappropriate physical contact.
Yes.
So we're going to provide some suggestions to you regarding that, including what that range of discipline may look like. And then you all are going to provide recommendations for the language related to felony convictions prior to obtaining a license. And then we will have all of those discussions via email in the meantime, and then wrap it up, refine and complete the licensure rule so that we can discuss it in workshop on July the 21st, and then ultimately vote on it in our board meeting on July the 22nd. Have I missed anything in this discussion?
No?
Not that I can think of.
Any closing comments from anyone on this call?
This was Wendy. I just want to thank you guys again for all the work you put into this.
Thank you for being so willing
that
to.
comment. Thank you, Wendy. Anybody else? Do we have a motion to adjourn?
So moved.
Second?
Okay.
Allison, all in favor? Aye.
Aye.
Any opposed? Fine. We probably didn't have to do that. All so much. I really appreciate your time today, and it's been a pleasure to serve with Allison and Wendy. Thank you.
Thank you.
Have a great rest of the day and a wonderful weekend.
You too.
Bye.
Bye-bye.
Bye, thanks. Bye.